Good morning. My name is Muhammad Ali Awan and my US student ID is 240533320. Today my analysis will provide a detailed overview of Suleiman's rights and amenities against Amjad Furniture Store following the failed delivery on September 17th. We will be examining your position under the Sale of Goods Act 1979 as amended and the key principles of English commercial case law. It is important to establish from the outset that you are acting in the course of your business as a restaurant owner. This classifies you as a non-consumer buyer, while this excludes you from the enhanced protection of the Consumer Rights Act 2015. Your rights under the SGA 1979 are robust, particularly your right to reject non-conforming goods. However, this right is subject to strict rules which we will explore in detail. Someone's assertion that is too late to cancel is a legal position we will test robustly. Let's begin with the most straightforward brief. The tables you ordered 25 extra large grey marble tables. The delivery of 10 medium tables, marbles, 9 wooden tables and only one correct table institutes multiple fundamental breaches of contract. Firstly, under Section 13 SGA 1979 Sale by Description. You relied on the description extra large marble tables in grey when placing your order. The 9 wooden tables potentially do not correspond with this description. The principle from the case of Bale versus Taylor 1967 is clear. Where a sale is by description, there is an implied condition that the goods will match. A breach of a condition, as we will discuss, typically gives you the right to treat the contract as repudiated and reject the goods. Secondly, under Section 30 SGA 1979 delivery of wrong quantity. The seller has delivered a mixed wrong quantity, a shortfall of the correct items and an excess of incorrect ones. Section 30 subsection 1 states that if the seller delivers a quantity less than contracted for, you may reject them, while Section 30 and subsection 2 deals with the excess of quantity. The delivery of the wrong type of goods entirely falls under the general principle that the delivery must conform the contract. Crucially, the Sale and Supply of Goods Act 1994 introduced Section 35A, which grants you a right of partial rejection. This is vital here. You are not forced into an all or nothing choice. You could, for example, accept the single correct extra large marble and tables and reject all the others. As per Section 35A, by accepting the one of conforming item, you do not lose your right to reject the non-conforming 19 tables. Now, the 100x display chairs. The legal test here is Section 14 subsection 2 SGA 1979 satisfactory quality. Good must meet the standard that reasonable person would regard as satisfactory, taking count of any description of the goods, the price and all other relevant circumstances. Now let's apply this test. Description: they were sold as X display with minor wear and tear. This seats the expectation they are not new. Price: a 50% reduction is significant factor. A reasonable person would expect a lower standard than a brand new product. Relevant circumstances: the intended use is for a commercial restaurant. Durability and appearance are crucial. The question is whether grease marks and scuffs fall within the ambit of minor wear and tear one would expect for X display items, or if they are rendered the quality unsatisfactory. The case of Rogers versus Paris, L 1987, is instructive. The Court of Appeal that held that for a motor vehicle, quality includes not just its mechanical operation but also its appearance, finish, and aesthetics. By analogy, for restaurant furniture, appearance is a fundamental aspect of its quality. Grease marks that cannot be easily cleaned may well push the chairs below the standard of satisfactory quality for their purpose, even at a reduced price. Furthermore, you have only opened the box. This is crucial. Section 35 and subsection 2 provides that you are not deemed to have accepted the goods until you have had a reasonable opportunity to examine them to ascertain their conformity with the contract. Your partial inspection is a part of this process. You have not yet accepted the chairs. The sofa presents the strongest case for a breach of condition you specifically required, whether the leather would irritate those the skin condition. Someone gave an unqualified resistance. This is interaction triggers section 14, subsection 3, SGA 1979 fitness for a particular purpose. For this section to apply, two elements must be satisfied. First, you made to the seller expressly or by implication the particular purpose for which the goods were being brought. Your second one, you relied on the seller's skill or judgment. You made the purpose expressly clear by use by the public, including individuals with skin sensitivities. You then relied on someone's skill and judgment as a sales advisor when she gave her reasons. The fact that your order developed a rash immediately upon using is compelling evidence that the sofa was not reasonable fit for that communicated purpose. The classic case is Grant versus Australian Knitting Mills 1936, where underwear containing a harm chemical was held not fit for its purpose, entitling the buyer to a full refund. Similarly, a sofa that causes skin irritation is fundamentally unfit for its ordinary purpose. This is clear breach of the condition implied by section 14 and subsection 3. Now, this brings us to the core of dispute. Someone's claim it's too late to cancel legally. This means they are arguing or you have accepted the goods under section 35 SGA 1979. Acceptance can occur in three ways. First one is intimation of acceptance, section 35 and subsection 1a. You have not told the seller you accepted the good. Quite the opposite, you have phoned to reject them. An act associated with the seller ownership, section 35 and subsection 1. You have not, for example, sold the chairs to another restaurant or fixed them to the floor. Merely unpacking one box to conduct your examination is an act consistent with your right to inspect, not an act of ownership. Lapse of reasonable time, section 35 and subsection 4. This is the key battleground. You received the goods on the 17th and rejected them on the 18th. Is one day reasonable time? The case of Bereston versus Pemson Motors 1987, where 3 weeks was held too long for a new car, is often cited by sellers. However, this case have heavily criticized or for being out of touch with commercial reality. The more modern and authoritative approach is seen in Clegg versus Anderson 2003, where the Court of Appeal took a more pragmatic view, focusing on whether the buyer had a genuine opportunity to discover the defects. In summary, Suleiman, the law is firmly on your side. You have strong grounds to reject the goods, and you have acted within your rights by doing so promptly. Do not intimidate by the seller's claim. Your next step is crucial. Put your rejection in writing Thank you so much.